So we're going to jump back out of the encyclopedia article and go into Salmond on jurisprudence. This is the 12th edition, hardbound copy in front of me here on in my table, on page 316, where we find this: the uses and purposes of incorporation. You know, everybody's concerned about, oh God, these incorporations killing us. Yeah, but you know, it's tools. You know, it's like you got a hammer and you can either bean yourself over the head with it, or you can drive nails. Real good for the latter, and kind of a waste on the former. But anyway, there's probably nothing, John Salmond writes here, there's probably nothing which the law can do by the aid of the conception of incorporation which it could not do without it. But there are many things which it can do by such an aid better and more easily than would otherwise be possible. So it's a tool in the law toolbox. There are two chief devices for this purpose, jumping down considerably. There are two chief devices for this purpose, namely trusteeship and incorporation. The objects of trusteeship are various, and many of its applications have a source and significance that are merely historical. In general, its use as a mode of overcoming the difficulties created by the incapacity, uncertainty, or multiplicity of persons to whom property belongs. Incapacity. You know, you're just stupid, dumb animals, you know, fit for slaughter on the global landscape, right? You don't have the capacity. You're just a child. You're insane. You're incompetent, right? Insane children and adolescents. The incapacity. You're not smart enough. You don't know how to turn on and off the water valve in front of your house, you know. You don't know how to change a breaker in your breaker panel. You need to leave that to experts. Experts say. Uncertainty. Well, we're not really sure if you have this property or not. Not really sure if you even own this property. Well, you bought it with Federal Reserve notes. They're a toxic slime. They have no intrinsic value. This is just, you know, it's a medium of exchange, but it has no value. You haven't bought anything, right? You didn't give gold or silver coin. All you've done is discharge the debt. You've never paid it. I'm going to have to set up a trust here for you. But, continuing, who hold it for safe custody. Let's continue. The property is deemed by the law uncertainty or multiplicity. There you go. Very small print here, old book. Or multiplicity. There's so many people in the United States. Look at all these millions and millions of houses in foreclosure. Well, we're going to have to set this all up under a trust, right? Okay, so you've got incapacity, uncertainty, or multiplicity of the persons to whom the property belongs. Or you have a large family, so you set up a trust agreement. The property is deemed by the law to be vested not in its true owners, but in one or more determinate individuals of full capacity. You know, Father knows best, Uncle Suck, who hold it for the safe custody on behalf of those uncertain, incapable, or multitudinous persons to whom it in truth belongs. Now, this is our country. It doesn't belong to Uncle Suck, it belongs to us. But because we aren't capable of understanding that, and we're not certain that that's the case, and because there are so many of us, and as they say, you get 3 or more Jews in a room, and they'll never come to any agreement or consensus on anything. So we're in trouble here. In this manner, the law is enabled to assimilate collective ownership to the simpler form of individual ownership. It's, again, the collective triumphing over the individual. If the property and rights of a charitable institution or an unincorporated trading association of many members are held in trust by 1 or 2 individuals, the difficulties of the problem are greatly reduced. We don't have to worry about all those pesky Americans out there with rights. Just put them all, drop them all in a trust. And we'll be the trustee and they'll be the beneficiaries, and then we'll just rake off the top. You know, that's what they like to do in the Rothschild Empire. It is possible, however, for the law to take one step further in the same direction. This step it has taken, and has so attained to the conception of incorporation. This may be regarded from one point of view as merely a development of the conception of trusteeship, for it's plain that so long as a trustee is not required to act, but has merely to serve as a depository of the rights of the beneficiary, there is no necessity that he should be a natural person at all. This be an artificial person. corporation. It could be your town acting on your behalf. They're the trustee, you're the beneficiary, you got the water, and they got your money. And they got your property. He may be a mere legal concept, a municipality. God on earth, what is that? A water board, a soil and water conservation district, a watershed boundary, towering like giants as they come over the trees, right? He is one person, and so renders possible a complete reduction of common to individual ownership, whereas the objections to a single trustee in the case of natural persons are serious and obvious. The fictitious trustee, moreover, though not incapable of dissolution, is yet exempt from the inevitable mortality that afflicts mankind. That's right. Everlasting, omniscient, omnipresent corporations. They transcend the boundary of the physical and the flesh, and they go on as gods among men, the corporation. He embodies and expresses, therefore, to a degree impossible in the case of natural trustees, the two elements of unity and of permanence, which call for recognition in the case of collective interests. Always it's the collective. All those union employees. An incorporated company is a permanent unity standing over against the multitudinous and variable body of shareholders whose rights and property it holds in trust. All of your rights are held in trust. And all of your property is held in trust. You are a beneficiary, but your trustee doesn't want to give it back to you. It is true, indeed, that a fictitious trustee is incapable of acting in the matter of his trust in his proper person. This difficulty, however, is easily avoided by means of agency, and the agents may be several in number, so as to secure that safety which lies in a multitude of counselors, while the unity of the trusteeship itself remains unaffected. Gives you a lot of confidence, doesn't it? Helps you to understand why these lawyers get away with everything, because you don't understand this material. They know that. They got rid of the trivium and the quadrivium. You no longer are brought up with grammar in your mouth. You're no longer a phonologist. You're no longer a phonetic speaker. Now it's just all see, say, and if you see something, for goodness sake, say something, right? Continuing. Now this is out of Dillaboo and Howard's. We've talked out of this before, Principles of Business Law. Has to do with trusts, and we'll just jump over a whole gob and a bunch here and go right to business trusts. The business trust is an organization formed by trustees under a contract called a declaration of trust. Funny, it was a declaration of what? Independence. Executed by the trustees. Who are the trustees? We the people. Under the agreement, the trustees issue certificates of beneficial interest. That would be your Bill of Rights in the Constitution, which are sold to investors, and you bought it. Sold to investors? Would that be the Rothschilds? Would that be the City of London? Would that be J.P. Morgan Chase? Maybe. The New York Stock Exchange, and Euronext, and the Deutsche Börse, and London Stock Exchange, and the Canadian? Wow. The trustees take the capital, and don't they, in compliance with the agreement and operate the business, whatever it may be, as principles for the benefit of the shareholders. They've taken all your capital. Land, labor, and capital. They've taken that all. And they are holding it. And they're operating the business, whatever it might be, for your benefit as shareholders. Of course, now, unfortunately, the business has gone bust. And now you have a certain amount of debt that you're going to be saddled with for the rest of your lives. Such an organization avoids the statutory regulations of a corporation in that it is not a creature of the state. How could the United States of America be a corporation? I ask. CorporationNation.com. How could the United States of America be a corporation? Who gave the blessing? Where did they get their charter? They go, well, let's see. We need to have a charter for the United States of America. We need to have a charter for the White House. Who gives it to them? Wait, who do they appeal to? Pope of Rome? Black Pope? Mom over there with the dress and the scepter in England? Bank of England? Who do they appeal to? Sheikh Barabi? Such an organization, again, avoids the statutory regulations of a corporation in that it is not a creature of the state. So they couldn't become a corporation, they had to become a trust. And seeks as well to avoid partnership liability on the part of the investors. So they absolve the Crown and Parliament assembled from all debts, public and private. The courts, in most of the states, however, have held that if the investors under the trust agreement have a right to exercise some control over the management of the business, well, we'll have to figure that out right after this.